Assalamualaikum warahmatullahi wabarakatuh. This is part 3 for the lecture for the topic vicarious liability. So in part 2, we were discussing about in the course of employment, and there are actually four scenarios, okay, that we have to consider whether it still falls under within the course of employment or not. So the fourth circumstance or situation or scenario here, all right? What if the employee, okay, is involved in criminal act or has committed certain criminal acts, whether it is still be considered as in the course of employment? Especially, this is where it is stated as acting on the frolic of his own. Okay, meaning that here, as if he does whatever he likes. Okay, the act here, he does it, okay, according to for merriment. I mean, that's the literal meaning for the word frolic here. Okay, what's the meaning of on the frolic of his own? Acts which are considered to be outside the course of employment and accordingly not covered by the vicarious liability of the employer. So if the act is on a frolic of his own, then this is not within the course of employment. So we cannot hold the employer liable under vicarious liability. So the rule is that if the employee's act has intended to benefit him alone, or it is done, okay, the act is done in furtherance of his employment, so the employer won't be liable. Meaning that here, the employer won't be held liable under vicarious liability. But okay, if he has committed the thought for the benefit of his employer, or is done in furtherance of his employment, then the employer will still be held liable. Example, assault and battery committed by the employee. Let's have a look at the case, okay, in order to see the application or better illustration for the rule just now. The case is Keppel Bus Company Limited and Saad bin Ahmad. What happened here? That this is appeal case. Respondent was a passenger on a bus and the employee was the bus conductor. Okay, those days, this is the picture, okay, of the illustration of bus conductor. Usually, the one who is responsible to collect the fees, okay, the payment, okay, and then you are given the ticket by the conductor. All right. So they were the bus fare, not really the fee, sorry. They were arguing about the way the employee was treating an old lady. I mean, the bus conductor was treating the old lady not so nice. Okay. So after the lady got down, they started again. The passenger and the bus conductor. And this time, okay, it was a heated argument, and the employee hit the passenger, the respondent, with his punching ticket machine because he was holding the ticket machine, and respondent became blind. Okay, meaning that here he hit it direct to the eye, so it caused injury to the hand. He became blind, the passenger. So the High Court held that employer was vicariously liable. Okay, but when the case was appealed up to the Privy Council, the finding was that the state employer was not vicariously liable because why? When the battery occurred, so hitting is an act of battery. When the battery occurred, the lady had already left the bus. Okay, the passenger was no longer on the bus, and the conductor was acting out of emotions and not in the course of employment. It's like something personal. Okay, it was done out of personal. Okay, and it had already become something personal between the bus conductor and the passenger. So that's why the employer was held not to be liable for under vicarious liability. We have another case, Morris and C.W. Martin and Sons Limited, 1966. This is pertaining to a theft, okay, which was committed by an employee. So plaintiff sent her fur coat to X to be cleaned, and X sent it to the defendant, who was a specialist in cleaning, okay, because certain coat it needs specialists to do the cleaning because it's very fragile, sensitive. So defendant handed it to their employee, who then stole it. So the employee of the defendant, the specialist, stole the fur coat. So it must be very expensive for stealing here. So the Court of Appeal held that the employer was liable because why? The theft was a dishonest performance by the employee of what he was employed to do. So employee is supposed to do the cleaning. Okay? So the act was done in the course of employment. The theft here is still in connection with the cleaning act, cleaning work. So now, after Morris case, okay, we have another recent case which is Lister. In year 2001, we are going to discuss after this. So the court discussed thoroughly of how to apply the rule, how to see whether, in order to determine whether it is still considered as within the scope of employment or not. Before we go to Lister, let's discuss this case. It involved a fraud of the employee, Lloyd and Grace Smith and Company, 1912, very old case. The defendant solicitors, who are the employers here, okay, were found liable for the conveyancing clerk's fraud. So what the clerk did, okay, I'm not sure he or she transferred plaintiff property here, okay, he transferred plaintiff property into his name, and the clerk sold it for his own benefit. Remember, he's a conveyancing clerk. So House of Lords stated that the employers were vicarious liable because why? They had placed that clerk in that position to enable him to do what he did. So he has the power, the authority, the skill, the expertise to commit fraud here. It gave the clerk authority, the firm gave the clerk authority to do these transactions. And the plaintiff was also made to believe so. So this is what happened at law firm sometimes, because the clerk has so much power because they are very experienced clerk. As if they can do, it's like equal work to that LA, legal assistant, okay? But again, this case has to be considered in the light of the recent case, the case of Lister. Okay, let's discuss Lister, because this case basically discussed thoroughly, okay? What could be the finding, okay? The observation by the court. This is the case by House of Lords. So that's why it carries a high weightage. What happened here? The warden of a boarding house for school children that had emotional and behavioral difficulties. So it's special children. It's not normal children here. And the warden had systematically. So meaning that here it wasn't done once. Okay, it has been occurring for quite a number of times. Okay, systematically sexually abused the plaintiff who were residents in the boarding house. So residents, the children in that boarding house, okay, became the victim of sexual abuse here. So now, can we hold the warden's employer to be vicarious liable for the act of sexual abuse by the warden, the employee here? And House of Lords laid down this principle basically, okay? So to determine the scope of the employee's course of employment, the court should ask this thing. That's why it's very important the case here. Okay, it was discussed, or it was the observation was so thorough here. First, okay, whether the warden thoughts was so closely connected with his employment that it will be fair and just to hold the employer vicarious liable here. So on the face of this case, okay, the answer is yes. Because why? The sexual abuse was intrinsically, okay, essentially, inherently interwoven, okay, connected with the warden's duties, because warden is supposed to take care of the children, but he abused it, okay, sexually abused it. The thought was committed at the time and at the premise of the employer, while the warden was caring for the children. So while the act of caring here, it include, okay, improper, which is not supposed to be done, okay, which is supposed to happen, sexual abuse towards the children, special children here. And then the court held, House of Lords, okay, it was the employer's position as warden and close contact with the boys that created a sufficient connection between the act of abuse and the work that he had been employed to do. So he's the warden, he was so close to the children, okay, to the boy, that's what, and then he abused it. So his duty was to look after the plaintiff, and he abused his position. So that's why, on this basis, the employer was found to be liable. So since the case of Lister 201 here, all cases involving assault of the plaintiff and all cases involving criminal conduct, especially by the employee, should be now be considered in this case, okay, House of Lords decision, because this is the apex of the court lah, okay, highest authority of the court here. So it's very relevant to all cases which come afterwards. Okay, so it's still relevant until nowadays. Okay, so we'll see criminal act here whether it's still, is it interwoven, is it interconnected with the act which is supposed to do. Okay, all right, with his job scope, with the employee's job scope. And this is the analysis and conclusion from the cases that we discussed, okay, in this part. So if the employer has authorized the wrongful act, then he will be liable, okay, for his employee's act. And employer is liable even for acts which he has not authorized, provided, okay, especially from Lister's case, provided they are so connected with act which he has authorized, that they may rightly be regarded as modes, okay, although improper or unauthorized mode of doing them. So unauthorized mode of doing the act which is authorized, then liability is still there, okay. The employer will be held vicariously liable. So whether the job was a mode for him to carry out the wrongful acts, or did the job merely create an opportunity for the employee to carry out the thought. So this is another issue of question. So if the job created merely an opportunity to carry out the wrongful act, then the employer is not vicarious liable. So it depends how interwoven, how inherently related, okay, the act and the opportunity later. I mean the subsequent to the act here, subsequent to the act. Okay. But if the job was a mode for him to carry out the wrongful act, then the close connection is established, okay, between the wrongful act and the employment, in which the employer will be found liable as well. Okay, is it a mode? If it is a mode, then liability is still there. Okay, and this is what we call as close connection test. Okay, closely connected. So close connection test. Okay, all right, we are done with this topic. So altogether, there are 3 parts of the lecture. So hopefully you are able to watch, and then you are able to understand all the lectures. All right, with that, thanks for listening. So hopefully you spend some time to view all the recorded lectures, okay, especially all the topics lah, basically, okay, that I have prepared the videos. Okay, until then, Assalamualaikum warahmatullahi wabarakatuh.